to Armchair Criminology. I'm your host, Rick Decker. Today I'm going to do something a little bit different. We're going to talk about an actual case that I did a number of years ago. I just get tired sometimes of analyzing everybody else's cases from television and just talking about the sociological, criminological aspects of everything. And I need for my own well-being to lighten up the mood a little bit. So we're going to talk about a case that I did. And the thing people need to understand is that justice works for everybody or it doesn't work for anybody. And this case is surrounding an armed robbery years ago, back in the mid-90s is when this thing happened. And when I caught the case, it was a bank robbery. And the attorneys came to me and said, we really don't have much of a defense. I can tell you that right now. They ID'd the guy that did it. And we don't think that we have any hope in hell to get anything but a deal. So I started looking at the case, and I would talk a lot about the 7 critical sins of criminal investigations. And this is one of those situations where if you don't follow the steps of the investigation, the attorney would have been right, the client would have been doomed. So I started looking through the file, and there wasn't a whole lot in the file, except that so-and-so had, we'll call him Bob. Bob robbed the bank, and everybody in the bank saw him because it was just 5 minutes before lunch. They were getting ready to lock the door for lunch. Bob walks in, displays a weapon, and robs the bank. Now, we had 5 witnesses, all employees of the bank. That was the only evidence that they had. Think about it. What's wrong with this picture? Not the one before you, but the concept. Tell you what it was. Nobody made any mention of the film from the cameras in the bank. Now, this is back in the mid-90s. And this is when people still were responsible for loading the cameras, changing the film. Okay, they went to, some banks went to closed circuit TVs where they changed the the DVD player tapes every 24 hours, and they would hold them for 30 days out, and they would eventually get re-recorded over. But nobody had done that. And there weren't any tapes. So I decided I was going to go interview these 5 witnesses. So I knew what door the bank had been entered from. And there were 2 entrances. One was the lower level, one was an upper level. And the upper level is where the guy came in at. So I walk in and I stood exactly or approximately where I thought my defendant would be standing when he announced that this was a robbery. And I walked in, stood there for a minute, and then walked over to the bank manager, handed her my card, told her who it was. And she looked at me and she says, I wasn't sure what you were doing. And she goes, we were robbed. And I said, yeah, I'm here to tell you. That's why I just told you I'm an investigator and I'm looking into the robbery that just occurred. And she goes, I thought it was this guy at first that walks around town that's homeless. I didn't realize that we were being robbed. What guy? Well, that guy that walks around with the cane that, carries the gray Walmart bags all the time. I said, yeah, but he's not homeless. And she goes, well, I thought it was him. You thought it was him? Yeah, I thought it was him until he began to speak. She goes, they didn't make a connection, didn't connect two to two, two and two. And I had asked her, I said, okay, well, there's no mention of the tapes. Where's the tapes? The FBI have the tapes? Oh, there are no tapes. No tape. No, that's why there's no mention of the police report. They had not been loaded from the previous month. I don't know why, but it just wasn't done. Now, there's a thing in the criminal justice system called reasonable doubt. I know you all have heard about reasonable doubt. So I knew who this person was that she spoke about, that she thought our defendant was. Not only did the bank manager, but four of the other subsequent tellers also gave me similar statements saying they thought it was, that's called the cognitive guy, George, the guy with the cognitive impairment, George. And they all thought it was George. And George had an account there. But George also had a history of being vile, aggressive, and violent. But they looked similar. Now, finding George wasn't really a problem. But George never talked to anybody. I had run into him a number of times in the community, and he was always a threat to somebody. You had to watch out for him. So I found George, and I knew I wouldn't be able to talk to him, but I was able to take his photograph because he was out in public. And once you're out in public, you have no right of expectation of privacy for somebody not to take your photograph. So I took his picture. Now, I knew our guy had been ID'd by the 5 tellers on a photo layout. I knew that at the time of the robbery, those employees were the only people in the bank other than our defendant. But nonetheless, we had to provide some type of defense. And the only defense that you have sometimes is the truth. And the suggestion of reasonable doubt. So I took this picture of George and I blew it up as big as I could get it to where it did not distort. And the characteristics, too bad, and that when you looked at the picture of George and then if you looked at our defendant, Bob, you could tell that there was definite similarities between the two. Their stature was the same. Their skin color was the same. Their hair was similar. The slight differences in the hair. The way that they walked was different. However, their demeanor was also quite similar because our defendant was not a nice guy anyway. Okay. So we get into the courtroom and the litigation is going back and forth, between the attorneys and the witnesses all testified and pointed our guy out. So I had handed in the reports. I had told the attorney, on your redirect, ask somebody who, if they thought that our guy was somebody else that lived in the community. The attorney did that to all 5 of these people. Now that meant I had to get on the stand. And, so they put me on the stand and I had this picture up on an easel covered. And this is the closest thing to a Perry Mason moment I ever got in my life, okay? Because that stuff just doesn't really happen. And so I went through my investigation reports, and I had indicated that the defendant, the witnesses had all told me the same thing, like they had testified, and that Their testimonies were consistent with the reports that was given to me, and with one exception. And the district attorney made the mistake of saying, well, what is that exception? And I said, well, they all told me that they thought Bob was really George, who lives in the community and is cognitively impaired. And she laughed at me and she said, that's all you got, Mr. Decker? And I'm like, well, I mean, it's what's happened. I said, I have the proof. And I said, if the judge will let me submit proof, I mean, I have it right here for everybody to see. So I got down up from the stand, I uncovered the picture, and all of a sudden I heard from the jury pool. They looked at the picture and they looked at the defendant. Our case rested. It took them 4 minutes to render a not guilty based off the fact that every one of the employees had said, I thought it was George in the picture. So the moral of this story is following the evidence, even though in light of having no defense, is quintessential to giving your defendant a chance for due process. Now, I'll tell you, he flat out told me he was guilty. He did it, and he should have went to prison for it. Okay, but I had to do my job, and I provided reasonable doubt enough where the jury pool concurred that it could have been George instead of Bob, because Bob never got on the stand. Bob never said, I flat out did it in court. So, and the lack of the film, the lack of any audio recording, the lack of any law enforcement testimony as a witness, no fingerprints were provided because Bob wore gloves. It was winter. He had gloves on. And to be frank, if he had not had gloves on, you know, the public part of the bank would have had so many fingerprints around, it would have tainted the evidence, and they wouldn't have been able to get a clear fingerprint type up off any of the counters, the doors, or anything. It just would have been impossible. So the moral of the story, once again, is follow the evidence, be cognizant of the 7 critical sins of a criminal investigation, because bias, pre-formulated opinions, the lack of following the evidence, letting the story lead you instead of the evidence lead you, causes problems. Following the evidence will, set you free, so to speak. Now, the thing that I want you to know is that this defendant, we already, I told you he did this, but he walked out of there laughing and smirking, okay? But 3 weeks later was arrested for stealing a purse off of a little Asian lady in a local community in the same county. And this woman beat the holy crap out of him with this purse. He had bumps and bruises, and she broke his cheekbone, hitting him with the purse as he was trying to steal it. So he was subsequently convicted for that. And not all criminals are smart. Let me say this, okay? And he had wrote the judge a letter taunting him, because it was the same judge for the armed robbery case and the same defense team. And he said that he knew he was going to get off this time because, they didn't have anything. Well, every case is different. They had more than enough They had witnesses, they had cameras from the shopping center, they had the victim that could identify him. His alibi was not solid. In fact, he said he was working at the time at a place, and they brought in the record keeper of the company that he worked for, and he had been terminated 6 months prior for company theft. So that's the basis of this show. I hope you enjoyed me analyzing this case and talking a little bit about, the reality in criminal justice. I hope to see you again next week. Thanks for watching. Until then, let's take care of one another. Carpe diem.